Good morning, everybody. I'm Jane Fielding. I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome so many of you to this, the fourth and final webinar in our series of annual update webinars for 2022. Our topic for today is developments in trades union law. Over the last couple of years, we've seen a sort of increasing level of activity amongst unions, particularly in the gig economy, but also in the public sector and the private sector as well. And there's been, as you'd expect, litigation as a result. So our topic today aims to bring you up to speed with some key case law developments, but also to give you an awareness of some trends that we're seeing in this area so that you can be mindful of those going forward and of what's coming down the tracks. So our speaker today is Jonathan Chamberlain, one of the partners in our team here in the UK, with several decades, you won't mind me saying that, of advising on industrial relations issues, as have I. He has a particular specialism over the years in manufacturing and the airline industry in terms of industrial relations issues and helping clients with their union relations. Jonathan's going to speak for about 25 minutes. We will leave time for questions at the end before we close at 11:40. As ever, if we don't quite get to your question, don't worry, we will follow up afterwards by email, so you will get an answer one way or another. If you want to use the question and answer function, the Q&A function to ask questions, which is at the bottom in the middle of your screen, the chat function's disabled today. If you have a tech issue, hopefully you won't, but if you do, also please use the Q&A function to try to get some help with that. Lucy Strong, who's our technical support today, will do her best to sort that out for you. And I will flag this again at the end, but we will be sending feedback forms around by email afterwards and would really appreciate it if you would fill those in. So I will now turn my microphone off and hand over to Jonathan.
Thank you, Jane. Good morning to a select but very interested group of you who have decided to join us for what 30 years ago, no, more than 30 years ago, 40 years ago in the UK would have been a vital and pressing topic, but is now perhaps more of niche interest. I'm assuming that you're here because you are a business which recognises trade unions or which might be recognising trade unions in the near future. And that, of course, places you in a small minority in the private sector, obviously different in the public sector. But for those of you who do have to grapple with these issues, these two cases represent a step change in union power. And they come about not because of recent moves in the political consensus, not because of economic action by trade unions themselves, but because of the effect of human rights legislation on UK trade union law and the increasing willingness of judges to take that legislation into account in the industrial relations sphere. Now, as you know, if you've been to our webinars before, we are about giving you practical answers to practical solutions. In the unlikely event that any of you have tuned in from a university or you're a student expecting me to write your essay for you, that is not going to happen. We're going to talk about the practical implications of these cases, although the law behind them is absolutely fascinating. I will have to go into it on some level of detail because, quite frankly, you know the cliche, if you think you've understood what's going on, then you haven't. Very much applies here. We are looking at legislation which is having to bear a weight and words which are having to bear weight which they were perhaps never intended to. That's sort of heretical because, of course, the very jurisprudence of the case, it says this is what the words were always supposed to mean, but I'm not quite sure that's the case, and we'll come on to that in a moment. So we are going to have to look in a little bit of detail into the law. But when we sent out the invite for this webinar, there were two questions. The first is, do unions have a veto over changes to terms and conditions? And the second is, we all know that employers can't lawfully sack employees who take part in industrial action, if that's within the protected period. Can they do anything else unpleasant to them, to punish them or disincentivize them, if I can put it that way, from taking part in industrial action in the future? The answer to both questions, you'll be relieved to hear, is no, but. And it's obviously the but that we're going to be spending a lot of our time exploring. So let's deal with the first question. Do unions now have a veto over changes to terms and conditions? And what this question relates to is section 145B of the Trade Union and Labour Relations (brackets Consolidation) close brackets Act 1992, TULCRA. Trips off the tongue, doesn't it? Now you know, as soon as you've got a section with a B in it, an uppercase B, not a little brackets B, that it's been shoved in there later, that it wasn't part of the original legislative scheme, and that suggests it's a bit of a botched job. And this was a bit of a botched job, but it's a vital botched job. Section 145B was introduced because the government lost a case in the European Court of Human Rights, which held that our trade union protection laws were insufficiently strong. And we'll see how in a moment. We're talking about the case of Costello and Dunkley, and we're talking about a Christmas bonus. So what I'm going to do is I'm going to set out the section 145B, what the case is broadly about. Then I'm going to talk about the facts of Costello and Dunkley. Then I'm going to talk about what the issues were, the very stark issues were. And then I'm going to try to make sense of a Supreme Court decision which decided the case on a different basis from the Court of Appeal. And although it was a unanimous decision in one sense, in that it supported the union's position, the judges were divided as to how the legislation worked. So we'll try and make some sense of that and its practical implications. But let's start off with the first of those. What is the relevant law about? Well, section 145B says that if an employee makes an agreement with the employer, and the effect of that agreement is to achieve a prohibited result, and the prohibited result is that that term is not then determined by collective bargaining, then the agreement is void, torn up, doesn't work, and the employee is entitled to a payment, and I had to write this down, it's a very exact figure, £4,431. And it's a fine, not compensation, it's a fine. The effect of that means that if an employer agrees new terms and conditions with the workforce that contravene this section, then not only is that agreement void, but the employer is going to have to pay a price of thousands of pounds per employee for having reached the agreement in the first place. So you can immediately see that this is very material, hence this talk of a veto. So second thing, what is Costello and Dunkley about? Well, it's about a Christmas bonus primarily. It was negotiations between employer and union on the pay round and what was the amount of the annual Christmas bonus, and then changes to terms in return for increased pay and the bonus, which were revised overtime and Sunday working arrangements. Negotiations began in October. By the time we're getting up to Christmas, time off Christmas bonus, no deal has been reached. So a ballot has been taken. The workforce are not in favour of accepting the employer's offer. So with Christmas coming up, the employer goes over the head of the union, writes to employees individually and says, if you accept these changes, then you will get your Christmas bonus and otherwise you won't. So guess what? In the few weeks before Christmas, most people sign up. Now, the unions say, right, and here's my third point. What is the at stake here? What are the arguments in the case? The unions say, you have achieved the prohibited result because an agreement's been made which has deprived the employee of a term that would have otherwise been collectively bargained. And the company initially say, well, that can't be what section 145B means, because we're going back to collective bargaining with the union. It's only this round, as it were, that we've opted out of. We've negotiated with the employees directly. We're not de-recognising the union. All the agreements remain in force, and this time next year we'll be back on the table talking in the usual way. And the union said, no, the meaning can't be that that we're deprived of collective bargaining completely. It has to relate to the particular term that we're talking about. And that was the battle line, and that went back and forth in the tribunal, found in favour of the union, in the EAT, which did in the Court of Appeal, which found in favour of the company. And here's the interesting thing, okay? The Court of Appeal took the line that I've just described to you, that it must mean to deprive collective bargaining altogether. By the time it got to the Supreme Court, that was no longer an argument that the company was running. And it wasn't running it because it was obviously, in the real world, completely unsustainable. Because how could you possibly tell whether this was a forever bargain or not? You wouldn't be able to see at the time. And there are 3-month time limits for bringing these claims. So what are you supposed to do? Wait until next year's bargaining round. And then if that takes place, you haven't got a claim. And if it doesn't take place, then you do have a claim, but you're now out of time because the irrelevant event took place last year. So it's a nonsense. And having argued it in front of the Court of Appeal with a straight face and won on that basis, the company realised they couldn't sustain that in the Supreme Court, so dropped it and put forward a much narrower argument that it has to be about, well, the obvious intention is to deprive of collective bargaining. It has to be the express intention of the employer. And the Supreme Court said, no, that's not how it works. It does relate to the particular term. And there was a division between the majority of the Supreme Court and the minorities as to how that worked. The majority went with a sort of causation argument, if this was the intention of the employer to do it. But as commentators pointed out, that doesn't really work, because sometimes you're not dealing with a recognised trade union, and the only discussions that can be had in those circumstances are about the size of the bargaining unit, and it's a one-off, so it doesn't really work. The minority decision was really much simpler, and it said, does it have this effect, and has the company done this to try and opt out of collective bargaining, or does it have another business reason for doing so, a legitimate business reason for doing so? And I think the better view is that the minority are probably right, and it'll only make a difference, though, in a very few cases. And the effect of that, the practical effect of that, is this. The employer has to exhaust the collective bargaining procedure with the union, and it has to do so in good faith. Now, that second point is a really novel concept for English lawyers. We're not used to looking at people's good faith in entering into negotiations and discussions, but that is what employers now have to do. We can't just do this as a tick box exercise. So what are then the practical implications for employers? Well, the one that immediately struck me is, having worked with unionized clients for decades, as Jane so politely put it, is that there are collective agreements and then there are collective agreements. And some of them are about 2 pages long, and some of them would fill a lever arch file. Indeed, they probably still do, because nobody's got around to digitizing them. And some of them will have exhaustive processes, and you have that old concept, failure to agree. We now register a failure to agree. You see that in the car plants, where there's been strong union presence for many years. But a lot of bargaining agreements literally just say that the union is recognised for pay and conditions, not much more than that. So how does the company tell when it's exhausted the collective bargaining procedure? And how much time have companies spent in recent years looking at those agreements? They're not legally binding anyway. They were only ever binding in honour. That's in the legislation itself, ironically. So it's not something to which we lawyers have paid much attention much of the time. But now we're all going to have to. And the second practical implication is around something, another hot topic in employment law at the moment, which is fire and rehire. Because this it's a sort of reverse Yellow Pages for those of you of a certain age. This term is not just there for the good things in life, but it's for the bad things as well. If you're trying to reduce terms of employment and you go over the head of the union and you're saying to a workforce, you must sign up to these new reduced terms of employment because you don't, there will be redundancies. And in those circumstances, people often sign up and you go through a fire and rehire exercise. You can do that in consultation with the union, but they don't have the power to block it. Well, here, that process is now underpinned by a much tougher statutory regime, where what you say to the union, when you said it, how you said it, is going to be subject to the court's scrutiny if the agreements you reach with the workforce are not going to be torn up and you're not subject to a whopping great fine, or it's effectively a fine. So, on that cheery note, we shall move on from section 145B, and we won't go very far because we're going to go to section 146. And this one is legally even more confusing, but let's just take a step back. What is section 146 about? You remember my second question. If an employer wants to, I hesitate to use the word punish, because obviously we never ever want to punish our employees. We don't think in those terms. And certainly as this is being recorded, it's not something I particularly want to be going around live on the internet, as it were. It is such a useful word, though. If, and as you'll see when we come to the facts of the case in question, it was where employees had taken industrial action and the employer said, right, if you're going to do that, then I'm going to do this. What other word can you use? Well, the legislation uses the rather drier term subject to a detriment. So perhaps I should stick with that. But if one's going to be euphemistic about it, how can the employer disincentivize employees from taking industrial action? Because there are specific restrictions on dismissal. We know that, but what about actions short of dismissal? Well, there wasn't anything specific in the legislation. Section 146 is not about that. Section 146 is about protecting trade union officials, or trade union members, going about the course of their duties or activities. That's where it originated in the scheme of a conceptual scheme of UK industrial relations. But calling it a conceptual scheme is giving it a dignity and a sense of structure that it doesn't really deserve. As you all know, our trade union legislation is built on decades of economic warfare and represents victory in the 1980s of Margaret Thatcher, not really compromise. So it's something has now been done to the language, which, I mean, it literally isn't written in there. Section 146 contains a prohibition on detriment to an employee in connection with trade union activities. And we've had two recent cases, Mercer and Ryanair, where trade union activities has been held to include taking part in industrial action. And the effect of that is best seen in the second of these cases, Ryanair, where it was about pilots. And one of the great benefits of working in the airline industry is travel. You get travel concessions, normally standby. You can, hang around at the airport, where you may well be hanging around anyway, because it's where you work. And if there are free seats on the plane, you can take them. It's a fantastic benefit. After the pilots had taken part in industrial action, Ryanair withdrew that benefit from the pilots. They're not sacking them. They are, though, subjecting them to a detriment. And section 146 talks about trade union activities within, outside of normal working hours. And you can see there, it's talking about a trade union official with meetings in the evenings and things like that, or within normal working hours with the employer's consent. And that obviously covers the situation that you get in workplaces with long-standing union recognition, where there are full-time officials paid for by the company actually embedded in the organization. They have their own office on the shop floor. Some of you will be very familiar with that. Others of you on the webinar will be scratching your heads, I've little doubt, but that is how it works. And so what the EAT did in Mercer, confirmed in Ryanair, was to take, once again, human rights legislation, Article 11, freedom of association, and say that the legislation had to be read consistent with that. And you can read down into the legislation that taking part in industrial action, which is lawful, must, because it is lawful, effectively be with the employer's consent, because that's how it has to be. That there is the whole scheme of the legislation, the whole thrust of Article 11 is that it can be lawful to take industrial action. And so taking part in trade union activities includes industrial action. After all, industrial action is an inherent part of trade union activities. Now, there's lots of judicial language explaining, well, that must be what the section had meant. Speaking personally, and as someone who has been doing this for decades, thanks again, Jane, I am not convinced by that. This section smacks of protecting trade union officials going about their duties primarily, or ordinary employees in respect of joining a trade union and doing stuff in and around trade union. I don't think it was ever intended to apply to industrial action, but now it does. So the answer to the second question I posited is, can employers punish, subject to a detriment, disincentivize employees for taking part in industrial action, provided they don't sack them? The answer is no. That is now prohibited by the statutory scheme. You can't withdraw the travel allowances. But how far does this go? And here's the practical implications of this. And this is where it can get really, really difficult, because of the way the section is worded. Let's suppose a scenario like this. You're a big company. You outsource a bit of your company where you've got the most trade union issues. Now, because TUPE applies, that it just means they're still going to be working there, the same people, but they're going to be someone else's problem. And there's industrial action, there's a strike. So instead of giving that contractor the jobs to do on the site, you give it to another contractor whose employees haven't gone on strike. Now, who is subjecting whom to a detriment in that scenario? The new contractor is saying, well, it's not, it's not me, it's nothing to do with me. I'm just not being given the work that I can pass on. But the original employer, as it were, the producing company, may well have taken the decision precisely to punish those individuals. And there's nothing in the legislation that, on the face of it, covers that scenario. The employer of the individuals can say, I am not subjecting them to a detriment because they took part in industrial action. I'm just not giving them work which I haven't got to give. Now, what I can see is that there might be some more dragging in of the human rights provisions there, because otherwise you've got a back door, a back route around the legislative protection. But that's going to require a lot of judicial drafting. And these are real scenarios. These are happening today. Okay, this is not something that I've just made up before I came in here. So because the legislation is a botch, because of how it came about, it's not clear how this is going to work itself out. But we can see there will be lots of problems coming down the track. The practical advice is check your collective agreements, see what the dispute resolution procedure is, make sure it's followed in good faith. Everything is going to take longer and have to be better documented. And in the outsourcing scenario that I've just described, if you are the contractor with the people who are taking industrial action, make sure your contracts with the client protect you in that scenario from decisions taken by the client over which you have no influence. That was a whistle-stop tour of some really very difficult law. That was the 25 minutes that Jane allocated to me. So, Jane, do we have anything in the Q&A? Anything you having heard that you'd like me to pick up on in any more detail? I've got some questions here, so I'll pick up on some of them. Is failure to agree something the company has to recognise? I think the answer to that is yes. Do I feel the protection from detriment may extend to industrial action which may be unlawful? Yes, I think it does. What if the employer doesn't believe the trade union is acting in good faith during wage negotiations, i.e. stringing it out to frustrate the process? Very tricky. That's going to happen a lot. And to some extent, no change there. It often has happened. But it's going to require close management, close attention. It's going to be very difficult to do without lots of highly artificial emails and correspondence going across. I believe you are not acting in good faith here, all this sort of stuff. But there is going to be a new level of skill and commitment required in conducting negotiations with the trade union.
It does cut both ways as well, doesn't it, Jonathan? The good faith, the union also have to. So there may.
And can I just say thank you very much, Tracy. You didn't freeze. We saw the whole presentation. I'm going to take that as being a good thing. Yeah. So I'm really pleased you've said that to me. Otherwise, I'd be feeling very uncomfortable now. Jane, do you want to pick up on any of the highlighted questions which you think I should go to first? I'm just skimming through them. You'll have had more chance to see them.
Well, when I dropped off, the ones that were already there disappeared, but there was one around, you mentioned failure to agree.
Yeah, I gave a very quick answer. I gave a very quick answer to that because I was just scrolling through. Does the company have to record failure to agree? The answer is very much yes, and the company has to record how it got there, and the company has to try very hard not to get there. For those of us of a certain age, there may be a bit of a heart sink moment there, because we have been in environments where failures to agree were almost everyday occurrences. Unions would raise points, management would go, what? It would go nowhere. We'd talk about it, and then there'd be a failure to agree. We're now going to have to approach those much more carefully, where we, the company, the employer, want to produce change at the end of the process. A lot of failures to agree used to come from, as I say, requests from the union. I've got one particular example, and it's so client specific I can't give it because it would absolutely tell you what the client was. So confidentiality rules prevent me from doing that. But the union asked for an absolutely extraordinary benefit because another plant had it. And when it was explained to them that that plant had very particular circumstances that meant that benefit was necessary, and there were no such circumstances present in the plant which they were asking for, the union was very disappointed by management's attitude and registered a failure to agree. And you to get that sort of thing coming in. Now I think it's going to require a much more substantial and important character. As I say, there will be those of you on the call who are thinking, what is a failure to agree? Because it's not an expression used in your bargaining process at all. And the last thing that many of you will be wanting to do is to revisit that bargaining process, particularly because if you do so, then you're guaranteeing that you're going to be spending hours in meeting rooms with trade unions talking about process rather than talking about substance. That said, if you have got an occasion on which you can invest in those processes without a major distraction of effort or causing yourself a major industrial relations problem, I do think that is worth doing. To have some sort of milestone process, which you would then at the end of it be able to evidence to court to say, look, we tried. And so when we went over the heads of the union to employees directly, we had done everything we could. What's more, we'd done everything the unions say we should have done. So I think those old failure to agree processes will once again be useful and perhaps should be brought into some collective agreements where they aren't at the moment.
At the moment, if you try to renegotiate a dispute resolution mechanism in a recognition agreement, what incentive have the union got to reduce the steps involved?
Yep.
There's a question here about QP. So what happens if you don't have a collective bargaining agreement, you don't have a recognition agreement, but you inherit a union under QP?
Well, if you inherit a union under QP, you've inherited the collective bargaining agreement, or at least you've inherited the union recognition and the scope of that recognition. Now, there isn't much case law on this, but union recognition, of course, is not a term of art. There is a recognised a statutory procedure for union recognition, and there are certain compulsory terms of recognition agreements which are included if you go through that route. But most union recognition is still voluntary, and therefore you don't necessarily have the same obligations even if you have a recognised union. The safe thing to do in the scenario I just described is to assume you don't just inherit the union, but you inherit the collective bargaining agreement that they used to work under, provided it's practical to do so. And it won't always apply, and there is a reason these things are not legally binding. Things change, and recognition agreements don't always catch up. But again, the practical advice there is work with the recognition agreement that they were working to previously. Now, it's not to say that's going to be easy, not least of which you're first going to have to persuade the union to give you a copy. you might be able to persuade the client to give you a copy, but that assumes the client has still got a copy, because these things have often been lost over the years, and you will often find that the union has got a much better archive and a much better record than if you're an outsourcing provider, than your client. That very frequently happens. The unions forget very little in our experience. So you may find yourself saying, well, if you want me to go abide by a particular collective bargaining process, you're going to need to tell me what it is. And you may then be able to go back to the client and say, is this what it is? And the client might not have the document themselves, because that does happen.
Yeah, there's a slightly broader question here about trends, and we have actually seen this with one of our clients. So they're unionised in the UK and are involved in some sort of dispute grievance from a union official in the UK, and they start getting lobbied or on social media support from foreign unions. So the question is, are we seeing an increasing sort of level of cooperation between unions at a sort of multinational level? And if so, does it really make a difference, do we think?
Is it increasing? Yes. Is it at the level where it's going to make a difference? Not yet. International labour has not kept up with international capital, and that still remains the case. Unions' primary duty is to defend their members' interests in their countries, the people they are accountable to. So yes, we do see it happening, but not much, and it's not making a huge difference at ground level in terms of industrial relations. In terms of social media pressure and things like that, well, absolutely. But in that scenario, campaign groups are just as much of a concern as trade unions.
Yeah.
There's one question which I've seen, Jane, which I do want to answer, which is a very specific one on the wording of section 145B, referring to an offer being made to an employee.
Yeah.
And if you are simply unilaterally enforcing a detrimental change, I assume it is the case that this section is not engaged. I would disagree with that, because it doesn't have to be a good offer. And the whole way that the contract is framed is in terms of offer and acceptance. And if you're enforcing a detrimental change, it's exactly the fire and rehire scenario that I touched on. The offer is a worse deal than you've got at the moment, but it's still an offer. Now, in terms of unilaterally enforcing a change, if you're not going through any offer and acceptance method, well, as a matter of basic contract law, that doesn't work. You can't unilaterally change terms of employment. I know there are clauses in some contracts which say the employer can, and I know that in one case that clause was determined to have worked, and I don't know any practitioners who think that that can possibly be right. But so I even if you have a unilateral variation clause, I think the way that I put it is the more significant the variation that you're seeking to impose is, the much less likely that that clause is to work, if it ever should work at all, which I doubt. So sorry, I wanted to pick up on that question. It's a really interesting one, but this is fire and rehire is very specifically a context in which the unions have said we are going to use this, and the unions are all over this. You know, we've had letters from unions which have been now referring to section 146, referring to section 145. They're absolutely live to these issues.
Yeah. Okay. Well, we've run out of time. We have got a few questions which we will follow up on afterwards, but thank you, Jonathan. Hopefully that was a useful flag to all of you who have joined us today, clearly grappling with these sort of issues day to day, and hopefully it's given you a practical steer. So as I mentioned earlier, we will send around the feedback forms by email when we close the webinar. Please do take a couple of minutes to fill them in and send them back. We will be looking at our mid-year webinars shortly, but we'll also be looking at whether there are discrete events we want to put on if they're of sufficient interest to people. There will also be recordings and transcripts of all the webinars on the website shortly, so you can go back and refresh your memories if you want to afterwards. So finally, just thank you very much to Jonathan and also to Lucy and to all of you for joining us today. So hope you have a good rest of the day.